HMRC criminal investigation, what to do, what not to do, and when HMRC may prosecute. A knock at the door, a dawn raid, a search warrant, an invitation to attend an interview under caution. For most taxpayers, these are things they never expect to experience. But if HMRC has opened a criminal investigation into your affairs, the decisions you make in the first few days can have a huge impact on the outcome. In this video, I'll explain when HMRC is more likely to pursue a criminal investigation, what your rights are, and the biggest mistakes to avoid. This video is for general information only and is not legal advice. If you are under criminal investigation by HMRC, obtain advice from a specialist criminal defence solicitor immediately. What is an HMRC criminal investigation? Most tax disputes are handled through HMRC's civil powers. A criminal investigation is different. Its purpose is to gather evidence that could potentially be used in a prosecution. HMRC has powers similar to other law enforcement agencies, including applying for search warrants, obtaining production orders, conducting interviews under caution, making arrests in appropriate cases, and seeking recovery of criminal assets. Importantly, HMRC investigates, but an independent prosecuting authority ultimately decides whether criminal charges should be brought. When is HMRC more likely to go criminal? Many people assume every tax issue leads to prosecution. That's not how the system works. HMRC's says criminal investigations are generally reserved for cases where a strong deterrent message is needed or where only a criminal sanction is considered appropriate. Examples can include allegations of deliberate tax fraud, use of false or forged documents, deliberate concealment or deception, money laundering concerns, organized or systematic fraud, abuse of a position of trust, repeated offending, conduct connected to wider criminal activity. HMRC also states that making false statements or providing false documents during a civil investigation can increase the risk of criminal consequences. The biggest mistake, talking before taking advice. One of the most common mistakes people make is trying to explain everything immediately. When people are frightened, they often guess answers, speculate, over-explain, make inaccurate statements, and these statements can later become evidence. So if HMRC wants to interview you, obtain specialist legal advice before attending. The objective here is not to be uncooperative. The objective is to understand your position and make informed decisions. What to do if HMRC contacts you? Well, if HMRC contacts you regarding a criminal investigation, first, stay calm. Easier said than done, I know. Second, preserve all records. Third, do not destroy, alter, backdate, or conceal documents. Fourth, contact a specialist solicitor experienced in HMRC investigations. Gather tax returns, accounting records, bank statements, company records, emails and correspondence, documents relating to transactions under scrutiny. Obvious, I know, but very important. Your legal team will need these materials to assess the case anyway. What happens during an interview under caution? An interview under caution is a formal criminal procedure. Anything you say may be recorded and could potentially be used as evidence. That doesn't automatically mean you will be charged, of course. And it means the matter is serious and preparation is critical. Your legal advisors will help you understand the allegations, the available evidence, the risks of different approaches, whether and how questions should be answered. Every case is fact-specific. What should you never do? Well, obviously avoid these mistakes: ignoring correspondence, destroying records, coaching witnesses, contacting others to align stories, providing false information, assuming HMRC has no evidence, discussing sensitive details publicly or online. Many criminal cases become more difficult because of what happens after the investigation and not before. Can a criminal investigation be defended successfully? This is a crucial question, really. Yes, but successful defense usually starts with preparation. For example, a defense team may examine whether allegations are supported by the evidence, whether HMRC's interpretation is correct, whether transactions have innocent explanations, whether the records support the taxpayer's position, whether procedures were followed correctly. The outcome may range from no further action to a civil resolution to prosecution, depending on the facts of the case. So, if HMRC launches a criminal investigation, treat the situation seriously from day one. Don't panic. Don't guess. And definitely do not destroy evidence. Get specialist legal advice, understand your rights, and approach the process carefully and professionally. If you found this video helpful, please like and subscribe and leave your questions in the comments. Thanks for watching.